right, Nigeria's oldest opposition party is tearing itself apart. The PDP is in free fall. But the real crisis, it is happening in our courts. Conflicting judgments, forum shopping, judicial somersaults. But is the judiciary saving democracy or strangling it? Well, good morning and welcome to The Agenda. I am Chike Obogo. You can be a part of this program by sending your tweets on the app X. The handle is @DominionCast, @DominionCast on the app X. Follow us and then let's engage ourselves on that platform. So, let's go straight to the point. Let's not pretend the PDP is not just in crisis. It seemed to be in coma. 2 national chairmen, 3 factional headquarters, governors defecting like it's a fire sale, and every time the party tries to breathe, a court exhales a new judgment. Just last week alone, a federal high court in Abuja suspended the PDP national secretary. And then, 48 hours later, a high court in Rivers State reinstated him. Then, a court of appeal in Port Harcourt stayed execution on both. 3 courts, 3 verdicts, 1 party in paralysis. Today, we ask, when judges contradict each other, who loses? Is it the PDP or the Nigerian democracy? Well, my guest this morning is a professor of law. He is also the Vice Chancellor of Protestant University, Rwanda, a legal scholar, and one of the sharpest legal minds on the continent of Africa, Professor Olu Ojedokun. Prof, it's good to have you on the agenda once again.
Well, top of the day to you. It's a pleasure to be invited back here.
Thank you. Flying from Rwanda to Nigeria, back in the studios of Dominion.
Yes, indeed, it's a pleasure. It's not just because one is able to breathe here intellectually, but also because of the ambience of the studio. So it's home.
Thank you so much, Prof. Well, let's start with the PDP. Yes, if we dissect Nigeria's judicial ping pong, as I'll call it, is it not a source of concern for you, especially you in the legal profession?
Well, I don't think it's so much of a concern, because what you get is you get courts of the coordinate jurisdiction. And what do I mean by coordinate jurisdiction? Which means that they are the same level. And of course, because we see things from a different perspective, even though the law should be plain, but the law is not always that plain. So it is not unusual that sometimes courts will take divergent positions. And that's why we have the appeal court, and that's why we have the Supreme Court. And in those instances, as you said, 2 different decisions by 2 different courts in 2 different areas, 2 different jurisdictions. And of course, the appeal court brought some sense into the situation by saying, let us stay this matter until we hear the appeal. I think part of the problem that we have is that in the earlier days, we had the Federal High Court was the Federal Revenue Court, restricted only in jurisdiction to admiralty, to banking, and sort of financial matters, those sort of things, intellectual property. And all of a sudden, the jurisdiction of the Federal High Court was expanded. It used to be the state high courts that had wide jurisdiction over everything, except those matters I mentioned previously. Yes. But now both courts have wide jurisdiction over various matters. Then you also have to consider that the Federal High Court is appointed by the NJC, but who nominates are not state governors, whereas the state high courts appointed also by the NJC, but nominated, of course, by the governor of the states. So sometimes the divergent interests come to view. But my concern is not with them. My concern is with viable opposition. The PDP, possibly, the oldest political party, been in government, for a number of years before they were voted out, are now comatose. In other words, they are facing a crisis. And some would trace the crisis to the presence of the federal minister, minister of the Federal Capital Territory, who is in the party, but some might suggest is fraternizing, you understand, with the ruling party. Yes, with the ruling party.
Yeah.
And therefore some will ask the question, you understand, is it the interest of the PDP, the opposition, or the interest of APC? Having said that, you have people like Fayose and Autumn, you understand, who are not necessarily in government, you understand, who are supporting Wike. So some, I suggest, it goes beyond Wike's personal interests. There are some fundamental issues that need to be resolved.
Well, let's start with the PDP. You've studied party crises across Africa. When you look at the ANC in South Africa and the likes. Is this the worst you've seen so far? Or is it the most judicialized in Nigeria?
Well, it's not the worst, but, you know, obviously the man on the street, the common man who sees the judiciary as the last hope, you understand, begin to wonder whether there's any hope at all in terms of when there's conflicting decisions. But I would say let's calm down a minute. You know, yes, there are conflicting decisions, but part of the reason is because the PDP itself has not got its house in order. The court shouldn't really be intervening where the party has its house in order. It is because the PDP's house is not in order. So I think the crisis is the worst for PDP, not necessarily for the judiciary. I think the crisis is more to do with the PDP not getting its act together. And this has been going on for quite some time. And I think there are a lot of people who have hoped that we would have a viable opposition, you know, in the PDP, not because they support the PDP, but because they think that in any democracy, you need to have viable opposition, putting the ruling party on its toes. And then I'm not even going to dignify any substantive comment on governors moving to the APC from the PDP because there's no evidence that they carry along the people. The elite can move to political parties. The question at the end of the day is, has it been tested? Are they carrying along the people in free, fair elections? To interest, of course. And you have to ask the question, you understand, and I'm sure we'll ask it, why are they moving? What is the reason for the movement? Is it because the APC has done fantastically well?
You know, I was coming to that issue of defections later on. But from what you just said now, do we see the courts now as the battlefield for political parties?
Oh, it has been for a while, where people who are unable to use the internal mechanisms of their political party externalize it and go to the courts. And you know, there's a doctrine of ripeness in administrative law. Ripeness means, is it really ripe, you understand, to be considered by external bodies? In other words, I might have a dispute with my employer, I might have a dispute with my organization, I might have disagreement, but there must be internal mechanisms by which those are resolved before the courts intervene. But it seems that we tend to jump that loop and immediately into the arms of the court, and that's where the court is finding it very, very difficult. You see, my own view is that many of these actions sometimes are frivolous, vexatious, you know, and should be dismissed. But it seems many a times that has not happened, and it only fuels, you know, the crisis, perceived crisis of the judiciary. There are many upright judges, you know, so I'm not even going to slate them in any way. What I'm going to say is that they are put in that position because political parties have not got their acts together.
Okay, so we'll do a quick autopsy now. Despite the fact that we're not medical practitioners, but we want to do a political autopsy for the PDP. 16 years in power for the PDP, and now they can't elect a national chairman, even with all the 17 lawsuits that are on ground. So what broke, actually?
No, I think what broke within the PDP was internal democracy. I think also what broke was the fact that, you know, there's a Pact Sunda Sabanda, you know, agreements are to be honored. You honor agreements, you know, or contracts. And I think they had a memorandum of understanding, even though the memo wasn't necessarily signed, where the power was supposed to shift to a particular region, a particular area, and it didn't. And I think that broke the back. Some might trace the original crisis to Abubakar's Atiku's refusal, you understand, to allow the South, as it was, you know, to take up their slot. And that since then, things have not been right. But some people may argue that that's not even the reason. That the reason is governor, the former governor of Rivers State, who is now a minister, Wike, who always wants to get his way. And when he doesn't get his way, of course, decides to scatter everything in his wake. Some may argue that. But I think, you know, that internal democracy broke within the PDP. And where you don't have congresses, the Congress acting the way that it should, where you don't have, what do you call them, the WP Working Party doing its job, the disciplinary panels, and all those mechanisms working the way they should, then people will flee and they will go to the courts.
Well, you just summarized the whole thing, because it's a basket full of so many things within the PDP.
Yes.
But if the party violates its own constitution, you talked about agreements.
Yes.
If the party then violates its own constitution,
Yes.
where else do they go?
Yes, thank you for mentioning constitution, because I even said memorandum of understanding. I even think it was even in their constitution. Well, the only place to go is the courts, and then you have to take what the courts serve you, And when you externalize conflict, you cannot blame the courts, because the court is not necessarily, in the middle or in the midst of the crisis, but the court has to, like a fair arbiter, has to make a decision, from that point of view. So I think the courts is where they go to. And I think we have to be thankful that at least they're going to the courts and they're not having it like what happened in the Wild Wild West in those days, when the fisticuffs and all manner of violence were exchanged, Operation Warfare. So I think at least the courts maintain some sanity. But I also think, you understand, that we should spare the courts, resolve things internally, so that at the end of the day, only the most important matters, the most significant, and the most fundamental of issues go to the courts. Our courts need to be dealing with more substantive issues. And what are they dealing with? They are dealing with political parties that are unable to decide who should be their national chairman or who should be their national secretary.
All right, let's look at this, Prof.
Yes.
In 2022, it was Wike versus Atiku.
Yes.
14 pre-convention cases.
Yes.
In 2024, we had Demagun versus Anyanwu. And then we had 9 cases in 3 months. In 2025, it was the Rivers State PDP with 22 cases and 11 conflicting, judgments. Prof, how did we get here in the judicial space?
Well, I can trace it back to the time of Gani Fawehinmi, especially during the military era, when so many vexatious and frivolous actions were filed and there was not any major consequence. Fawehinmi, of course, is one of my heroes, but at the end of the day, what is good for the geese is good for the Ghana. In other words, some of these cases are frivolous. And in the United Kingdom, where I've also practiced, and United States, there's a cost attached to when you file frivolous actions. In other words, you pay heavily. So you think twice before you bring an action which is frivolous, vexatious, or not based on reality. And there seems to be less sanctions here, or insignificant sanctions. So people just go to court willy-nilly, as if they're going to the marketplace, and they don't take it that seriously. And that's why we have that amount of litigation going on at the same time. I know my profession benefits from it because, of course, juicy briefs from politicians, you get paid, you understand? And of course, you go smiling to the bank. Okay. But certainly that's not the issue when we talk about our democracy. Because where the courts are preoccupied with matters that are frivolous and vexatious, then the common man who has more fundamental issues to do with their livelihood, issues to deal with employment, issues to do with other matters, you understand, which are of greater significance, are not dealt with because the court is overwhelmed, from that point of view. So I think the first step really, my own advice, on the bench, will be that vexatious matters should be dealt with accordingly, and people that file them, you understand, should bear the consequences. So they will think twice before you bring those matters forward. But political parties too have to get a grip. And they have to get a grip on their internal appeal or grievance mechanism to make it almost very difficult and impossible to go out. In fact, I know the people will bring the constitution, but I think once you sign your membership card, you're signing the fact that you would abide by the tenets of that political party. And many tenets of the political party says you would exhaust the internal grievance procedure. And if you don't, then action has to be taken. Let me ask the question. Some would suggest that Wike was involved in a number of anti-party activities. But the PDP's inability or willingness to use its own mechanism to address it or to deal with it, you understand, has come to roost. The chicken have come to roost because people have seen what Wike did and he got away with it. So why shouldn't they try it? Why shouldn't they try what he did and with the hope that they also will get away with it?
Well, you just made this stance now. You talked about your profession being juicy, especially when you get some juicy offers from politicians. Yes. So if you, as a Professor Ulu Ojedokun, on a lighter note, gets a juicy brief from a politician, would you maintain this stance?
Well, I would look at it. I wouldn't necessarily go to court. Not all briefs end up in court. Some of them are out of court settlements. In other words, you look at it and you go for some arbitration, some conciliation, and some mediation. And that's what's missing here. Those three aspects are missing. And sometimes the courts, especially in commercial transactions, there's a clause, you understand, in the commercial contract where you say if we cannot resolve these issues, we submit ourselves to arbitration. And I'm beginning to think that maybe political parties have to find a mechanism where they can submit themselves to arbitration, mediation, and conciliation, rather than wasting money, you understand, going to the courts on actions which may prove frivolous, vexatious, and of no effect.
So basically, it's not really about corruption.
No, I don't think, well, there is no country, let's be very careful, there is no country where there's not an amount of corruption.
Okay.
Even United Kingdom, even United States, you understand? So it is there, but it's not the significant, in my view, and the predominant factor.
So within the political party, it's just like they looking for mechanisms to settle internal
mechanism.
conflict.
Yes, and apart from that, you know that I don't like to use that expression, but politicians always also look into somewhere where they can leak, you understand? I mean, if you use vernacular, you understand?
Yeah.
They want to leak, you understand? And of course, when you have a political party that's been in opposition for a while and doesn't have access to regular government contracts and patronage, then of course, you know, their eye, you understand, is on something else. And I think people are weighing, can PDP return to power? And if they make the conclusion, I'm talking about politicians, that it can't, then they begin to look at the ruling party, and that motivates them. You understand? So there are people within the PDP today that are not members of the PDP. In other words, they are not serving the interests of the PDP. They are serving interests beyond the PDP. And that's what's complicating the matter. So their allegiance is not to the PDP or its constitution. Their allegiance is to their stomachs and to their pockets.
So this now leads me to the issue of defections.
Yes.
Now, we have sitting governors who have defected from the PDP to the All Progressives Congress to the APC. Now, if you look at the Electoral Act 2022, is there any judicial justification for these moves as sitting governors, duly elected under a platform of a particular party? Let's look at it from the legal aspect.
Well, from the legal aspect, I think the law covers them. They can do that. It's immoral, it is wrong, you understand? It's unprincipled, you understand? But they can do it. But the members of the House, the parliamentarians, are in a different kettle of, it's a different kettle of fish.
Okay.
When they move, you understand?
Their seat becomes vacant.
Precisely. Their seat ought to be, because
But many of them have moved.
Yes, and they use the excuse, and it's an excuse that is subjective, that there's crisis, there's division within the political party, because the Constitution provides for that.
That
When
clause.
there's division, yes, when there's division. And that is what they've been holding on to, you know, from that point of view. So part of it is the constitutional requirement rather than them. Part of it for the governors is the constitutional requirement, because I think it's unfair to the electorate, it's unfair to the people that went to the polls. When you as governor has been elected as a member of John's People's Party, you understand, and you get in and you decide that you want to move political parties. No, I think you should finish your term, you understand, or resign, and then move to John's People's Party. I think that's the moral thing to do. But it seems that most of our governors have no scruples. It seems that most of them are not moral. And that's why people like me will respect people like Governor Seyi Makinde, you know, from that point of view. At least from now, it's maintained, you know, a consistency. And of course, some people will respect Wike to a certain extent, you know, even if his spirit is not there. At
His
least
body is
bodily, he has respected that principle and remained within that political party.
Well, you made a point for the clauses there, or the clause there, in the case of an unstable, that's when there's crisis within the political party. So suffice me to say, or to ask you, that the crisis within the PDP, do you think it is well orchestrated?
Well, I think it's man-made. I think every crisis is man-made anyway. I think it's orchestrated by people who want it to be in perpetual crisis. There's a particular individual there who's not satisfied, except there's crisis within the political party. So is there a real crisis within the PDP? I'm not sure amongst the people there's any crisis. I think it's amongst the elite. And that's the problem we have. We have a democracy which is fueled not by the people,
but the
not for the people, not with the people, you understand, but by the elite, you know, whose interest is completely different. And the interest of the elite is that immediately I get to the National Assembly, immediately I get to the Governor's Lodge, immediately I get to the House of Assembly, the humongous allowances determine you understand, that I'm set apart from the people, and determines that I live a consistent, enduring life of luxury, while people continue to lavish, or suffer rather, in penury.
Let's take a look at the judicial bazaar. When I say judicial bazaar, I mean the conflicting judgments. You know, different, same facts, different courts, opposite outcomes, and then you look at it in its entirety. Is this normal?
Well, first and foremost, it depends on who is presenting the argument.
Okay.
I might present an argument in a profound way to a court, and the other person may not be as profound as me. And therefore, the court decides and presides and adjudicates on what's before it. And of course, if the other advocate is not as effective, versatile as someone else, then you might get different results. But the people have come to expect that once principle is established, then whatever court of the land, you understand, then the principle should remain and should be the same. But I would say that our constitution envisage that sometimes judges, you know, coming from different schools, you know, there's the law as it ought to be and the law as it is. They are the positivists, they are the naturalists, you understand. So there are people coming from the point of view, okay, how can I use the law as an instrument of social change? And there's some people say, no, the law should be as it is. Don't go beyond your brief. You know, don't make law. You know, so all those factors come into being. And that's why we have the appeal court. The appeal court is to check on the judges of both tendencies. You know, and of course the Supreme Court, of course, looks at everything.
The final arbiter.
At the final arbiter. So I would say that until we get to places like the Supreme Court and the Court of Appeal, I'm not so overtly concerned. I'm concerned, of course, for the pockets of the politicians, you understand, that keep on spending money on litigation. But I'm not necessarily overtly concerned about the judiciary, because it will self-correct itself at the judiciary, at the appeal, and ultimately at the Supreme Court if it gets there.
Okay, now let's give examples. Imo North senatorial case of the year 2020, the High Court, the Federal Court, and the Appeal Court gave 3 different judgments, 3 different winners in 10 days.
Yes.
INEC didn't know who to swear in at that point. It got to that point. INEC didn't know who to swear in. And then it got to the stage where the Supreme Court eventually picked just one person.
Yes.
Now, but the damage was done, right? Now, how do we forestall such occurrences in the future so we don't have such embarrassment, as it were? Because I see it as a bazaar. It's a judicial bazaar.
Yes. Well, what I think, for instance, let me just go fundamentally, and many of my learned friends may not agree. I think the pool from which we select the judges is so narrow. I think we do not go outside a normal pool. Very few academics, we have few that are appointed, you understand. Very few private practitioners are appointed. Most of who are appointed are magistrates, registrars, those that have come through the directors of public prosecution, those that have come through the ranks. And I think, of course, that narrows the perspective and that narrows the approach. And that's why sometimes you wonder what exactly is going on. I think broadening the base of the judiciary will help us with some of these decisions. Having said that, you know, from that point of view, I think the NJC has taken some steps since 2020 that you mentioned to make sure that there's a house cleaning that has gone on, and to ensure that judges who are not necessarily following the ethics, you understand, of their calling or of their profession are called to order. So I would say that it's not as bad as 2020, but we really had some bad times there then from that point of view. Judges are a reflection of the society in which they come from. They don't come from heaven, you understand. They don't come from abroad. They come from here. And of course, they are a reflection. When I was growing up, you understand, and I will get into trouble for this, I'm sure, you never saw judges, you never saw judicial officers in social events, also, you know, interacting. Their interactions were minimized so that they can maintain the integrity of their call, and from that point of view. So in instances where that is happening, it makes it more difficult for judges to be immune from what's going on. I also think one of the things affecting us in this country is the lack of juries. Yes, it costs a lot of money, but the lack of juries who act as the barometer of whether someone is guilty or not, and then the judge sticks to the legal interpretation, you understand, will also do us some good. Because a lot of times, the juries, you understand, your peers know what is reasonable and know what is unreasonable, and obviously can intervene to stop some of the excesses that we've seen in years past.
Yeah, you talked about the NJC. I'll come to the NJC because some have said the NJC, that's the Nigerian Judicial Council, seem to be slow, and that judges have been protecting fellow judges. We'll come to that. However, there's this narration of from number 4 to number 1, the issue of Governor Hope Uzodinma winning the election in Imo State. Can you break it down for the sake of this discourse? What really happened?
Well, we may even go further to the Amechi case.
Yeah.
Yes.
Yes.
In that instance,
Yes.
it wasn't part of those who contested.
Who contested?
Yes. From that point of view. I think what the judiciary seeks to do, and in that instance, what they sought to do was to make sense of the judiciary, the electoral law, from that point of view. And of course, they did calculations themselves. I'm not sure that's the role of the judiciary to do their own calculations. They did calculations, they excluded some numbers. Because where there's substantial non-compliance, and votes as a result of substantial non-compliance, then the judiciary takes it upon itself to exclude some of those votes. So what they went was substantial judicial non-compliance, electoral non-compliance rather, and some of the votes that were voted were excluded. And by the time they subtracted and detracted, what did they get? They now got number 4. In other words, they nullified the votes of the 3 other candidates, and they were reduced to that. But there would be some of us who would have argued that the role of the judiciary in those instances is to order a rerun, not to get involved as mathematicians. Many of us are not trained as mathematicians, you understand. We are trained as legal jurists, we are trained as legal practitioners, and we should stick to the law, from that point of view. So, of course, there was confusion there from that point of view. And I think maybe what the legislature needs to do, rather than, spend their time on other things, is to strengthen the electoral law, prescribe. Where there's no prescription, it gives the judges the ability and the power to bring in interpretation, which otherwise doesn't look reasonable. And I'm being very careful here. It doesn't appear reasonable. I'm not saying it's not, but it doesn't appear from that point of view. So some would say that was a travesty, where number 4 becomes number 1. But yes, some would argue that it was because of the substantial non-compliance that was going on with the votes that were recorded.
Yes.
Then some would argue that if that is the case in Imo State, then how come heads did not roll in the electoral commission? From that point of view, the INEC. How come heads did not roll? It means that questions have to be asked by INEC itself. Questions have to be asked by the local security agencies, those who are supposed to preserve it, from that point of view. And that's why some of us are hoping that the new chairman, somebody I know personally, Professor Amo Putan, you understand, will bring some sanity into these processes, where there will be accountability. I think, where elections are not run well, or where the judges discover that there's substantial non-compliance, then there should be actions taken against the officers or the officials that are expected to superintend. Because if they don't superintend over those elections, there are consequences. The consequences are not just about money, it's about the will of the people being subverted. Where the will of the people being subverted, then that cannot be described as a democracy, from that point of view. So why waste huge sums when at the end of the day, we are going to get people that we otherwise did not vote for?
Well, that's the case of Hope Uzodinma,
yes.
from number 4 to number 1. Now, it's a different kettle of fish with the Amechi saga.
Yes.
What really happened in his own case?
Well, the Amechi saga, Celestine Omea was sworn in.
Yes, as governor.
But there were some problems with internal democracy, where the president, as he then was, Olusegun Obasanjo, weighed in on the local party and cancelled the primaries that produced, Amechi from that point of view. That's what I remember, and ensured that the primaries produced, it cancelled. In fact, the primaries were cancelled.
It was cancelled.
And then Omea emerged. And so what the courts did, you understand, was to say, okay, yes, even though he has been elected, we are going with the party, not the individual. And that the candidate of the party, you understand, was Amechi, from that point of view. So they said PDP won that election. I think it was PDP, yes, then.
Yeah, it was
won
PDP.
that election. And so we give the slot to the PDP. We give the verdict to the PDP, not the individual. And he who should have been the rightful nominee of the party was Amechi. Therefore, Amechi is governor. That is how they extended that argument. There will be some people who would argue that when you're voting for somebody, of course you're voting for a political party, but you're not just voting for a political party, you're voting for an individual as well, from that point of view. And that's the reality of it. But that was the position the Supreme Court took. Since then, I'm not sure that decision has stood the test of time, because the judiciary or the Supreme Court can reverse itself.
You see, what you just explained now,
Yes.
that technicality
Yes, yes.
in that judgment
Yes.
seem to be suspicious, seem to be deceitful, in the sense that if it could work like that, oh, you're giving the winner, you are judging the party, the political party,
Yes.
as the winner. But when people defect from one party to
yes.
the other,
Yes.
it becomes a different case entirely.
Yes.
So, okay, so don't you think that the judiciary is the one confusing the polity?
No, and that's a conundrum, and that's a confusion, and that's why I think that judgment, that decision, that precedent has not stood the test of time, because it's not consistent at all. As we said, it's not consistent, in my view, with the tenets and the provisions of the Constitution, and of course it brings in about confusion from that point of view. I will tell you what another factor is. I mean, we slate our judges a lot, but one of the things is that if you see the dockets, and docket means the number of cases that the judges handle, is quite enormous, quite significant. Don't even talk about Supreme Court. Don't even talk about the court.
But it's their profession, it's their job. They shouldn't complain.
No, but it is the role of the government, of the executive, to ensure that we have enough judges, so that judges are not overburdened.
But
judges
we
are not
have
put under
many.
pressure.
We have many. Let's start from the basics now. We have many students graduating from the Nigerian law school year in, year out.
Yes.
So why is government not tapping on that, taking advantage of that, promoting people and let people grow, and then you have numbers in the judiciary?
Well, that would be a question for government, but I guess government will say they have limited resources for the judiciary, and maybe other resources for other.
But if they have money, if these politicians, if these people get into power, they have enough money to throw around to these judges.
So it's a question of priority, from that point of view. I think one of the things that Oshibajo did when he was Commissioner of Justice and Attorney General in Lagos
State
was that he ensured not only that more judges were appointed, but they were actually well paid. In fact, judges in Lagos became, the kind of, textbook, or I don't know, the example.
We pray to God to be a judge in Lagos.
Yes, in Lagos, from that point of view. But it doesn't seem that other states have necessarily followed, because of course there are resource implications, there are budgetary implications when you appoint more judges. And it's not only just appointing more judges, it's also building more courts. I see that in Oyo State they are actually investing a lot in that, because you have to have where they sit. We have many courts today that are not fit for purpose. What do I mean? I mean, they are leaky roofs, the air conditioning is not working. And remember that we as lawyers have to wear fancy dresses. What do I mean by fancy dresses? Our gown, our bib, black. You understand?
And he exhumes heat.
Of course. So all those sort of things, you understand, affect the delivery of justice, affects, you understand, fairness from that point of view. So I think the first thing is to urge our state governments, even the federal governments, to appoint enough judges at the end of the day. And of course, judges based on merit through the Judicial Council. So that at the end of the day, pressure is not too much. Because when there's too much pressure, there's some perverse decisions, or decisions you consider to be perverse, are made.
All right, we'll go on this break now, and when we come back, we'll talk more on the NJC, the Nigerian Judicial Council, and also take tweets. There are tweets already, and I'll be reading them out, and then Professor Lord Jedokun will be answering some of these questions. Stick around, don't go away.
Need a professional space to bring your vision to life? Dominion Television Studios offers state-of-the-art facilities perfect for your next broadcast, commercial, corporate video, or live event. With flexible rental options, cutting-edge equipment, and a supportive team, we provide the perfect environment for high-quality productions. Unleash your creativity. For bookings, email us at marketing@dominion.org.ng. Call us on 0705 506 1061 or 0916 101 1061. Check us out on Instagram, Facebook, LinkedIn, and TikTok at Dominion Broadcast, and on X at Dominion Cast. Book your space today. Dominion Television, your channel of choice.
welcome back from that break. It's still the agenda on this dial. Well, before we went on that break, we're talking about the Nigerian Judicial Council. Professor Olu Ojedokun is still here. Prof, the Nigerian Judicial Council, like I said earlier, some have said they're slow. And then we have this case of judges protecting judges. So where there is the transparency?
Well, the National Judicial Council, you understand, has a very significant role to play. And of course, the enormity of the decisions they make are such that you also have to be measured and you have to pace it out, and you can't do it in a hurry. But of course, I understand the fact that people feel that you have to balance this with the decision making, which is quick, which is fast, and which ensures that we don't have judges in place that are going to deliver travesties of justice. So yes, it may be slow in its mechanism, but I also think it's also about the kind of constitution, because it's the judiciary policing themselves. And I think we have to ask the question whether the judiciary really should be policing itself, whether we shouldn't have some input, external input. Of course, you will still have judges there. Maybe not serving judges, maybe retired judges. My own view is that you may still have judges, but not judges that are serving. Retired judges, forming part of the NJC, which means there will be a constitutional amendment. And because the retired judges are not burdened with cases, are not burdened with day-to-day activities, they might be very quick in delivering, you understand, on decisions. All
right, now it's time to take your tweets now. We have this tweet from at Grapeman saying, Prof, if courts stop taking political cases, won't parties abuse members?
Well, I'm not suggesting they should stop taking political cases, but I'm suggesting they should sanction those that bring vexatious, frivolous cases which should have been resolved internally rather than bringing it to the fore, so that only the most germane of cases, the most significant, come to the fore. Of course, we want people to be able to go for redress to the judiciary, but after they've exhausted, so that the doctrine of ripeness, after they've exhausted the internal mechanisms and organs within their political parties.
Well, there's this other question here, and it's from Grassroots Observer 98, at Grassroots Observer 98. It says, the judiciary is compromised. How can we trust reforms? That's a big one.
The entire Nigerian society is compromised, So I'm not going to separate the judges and say they're compromised. And I think, we have the question of how we deal with it. I've already said that the way we select our judges needs to be expanded, needs to be opened up. It's so closed, and it comes from a narrow perspective, narrow spectrum rather. And I think if we open it up, then the compromise that we're talking about may be diluted. So I think we just have to be bolder and more imaginative in the way that we choose and select our judges.
Okay, selection process has to be very, very circumspect.
And overhauled, yes.
Overhauled. Yes. But you see, we still have some legal practitioners, legal luminaries going into politics.
Yes.
Is that not a source of worry? Shouldn't there be a check for this to stop happening? Because when legal minds get into politics, there's a way they circumvent.
No, I don't think you should check.
And some people also say that when it gets to, for example, tribunals and all that they will get their cases heard first, and then they might be influenced.
I think there's a constitutional issue if you stop people of whatever profession from going to politics. But I think we should know when somebody is acting as a politician and when somebody is acting as a legal luminary or as a judicial officer. We, of course, we are members of the Temple of Justice. We are ministers in the Temple of Justice when we are called to the bar. So we serve, you understand, a certain criteria. But when we are acting as politicians, we're not serving as ministers in the Temple of Justice. We are playing politics, you understand? And of course, whatever comes with politics, we play the game.
All right, at Alade Gold 6473 on the app X is saying, is the PDP dead?
No, the PDP is not dead. Okay. Is it struggling? Of course it's struggling, but it's not dead. And I think if it dies, then there should be a worry in this country as to whether democracy can be maintained. Because at the end of the day, the government in power a lot of people are not satisfied with the government in power, and they need to have an outlet, whether it's PDP, ADC, or whatever. But PDP is not dead, but of course, care has to be taken so that whatever comatose state that it is, it can rise from that and play its active role as an opposition party, a viable opposition party in the Nigerian polity.
Well, do I then ask, is our democracy at risk at this moment, at this critical time?
I would say our democracy is struggling. I would say our democracy is critical. You know, I would say our democracy, you understand, is going through testing and trying times. You know, we can't have a political party having 2/3. That's 2/3 already. That's the APC within the National Assembly. It's dangerous.
Very dangerous?
It is very dangerous.
Okay.
You know, and in a situation where the political party, that's the APC, is always on your mandate we stand. We're not talking about, you know, we used to have a time when the was it the APC? Yes, when the APC, when Kola Saraki was there.
Yeah.
But we are putting a check on themselves because they were not necessarily following the agenda of President Buhari. Now, everybody's following, you know,
the mandate
the
agenda.
mandate on the mandate.
Renewed hope agenda.
Yes, so we have a problem there because sometimes the mandate or the renewed hope agenda has some problems. And it is the effective opposition that can say, yes, we may support the general direction, but there are some fundamental problems, and let's address these fundamental problems.
Okay, so, Prof, because of our time,
Yes.
Your final thoughts, are conflicting judgments a symptom or a disease?
Well, I think, you know, our brother judges, when somebody has already made a decision on a case, I think the right thing to do, you know, is to just leave the case and allow those people to go and appeal. I think the problem we have is that we know a case has been taken, we know a case has been decided on, coordinated jurisdiction, and another judge offers conflicting judgment. I think in those instances, the NJC needs to intervene to ensure that when people are unhappy with a particular decision, they go to the appeal rather than forum shop and go to a judge of coordinated jurisdiction, because that's a recipe for confusion. Because those judges are or coordinate, they're on the same level. It's the appeal court or the Supreme Court that can resolve those matters, not court of the same or similar jurisdiction.
So you're saying the judiciary is not the villain now?
It's not
The villain?
Yes, well, the judiciary has a fault in some respects, because obviously, if I'm a judge and a case has been brought before another sister or brother judge, I'm not going to rule on that, you understand? I'm going to advise the parties to either go and resolve it out of court or to go and appeal. Because why would I make a decision in futility? Decisions should not be made in futility. You make decisions so that they could be given effect, they can give effect, they can bring about change in society, transform social justice, not just for the sake of filling, what's it called, our law reports.
Now, leaving the judiciary now, you've been in Rwanda for some months, Prof. And would you want to compare, do you want to do a comparison of discipline, principle, way of life in Rwanda to what we have here in Nigeria?
First and foremost, Rwanda is a smaller country. But of course, they have a purpose, they have a plan, and they have a leader who's taking the bull by the bull by the horns.
Yes.
And of course, so there's discipline there. They have a strategic plan which they are there to, which they work to a development plan. And so they have some goals and a series of indices that they are applying themselves to. And because it's small and it's homogeneous in terms of one language, one people, some will say, you know, from that point of view, I think they have a better advantage than us. So as we speak today, Rwanda is a much better society, much more harmonious society, much more disciplined society, much more wealthier society than Nigeria is at this point in time. Does it mean it will always be the same? I think we have more potential in Nigeria, but a potential unrealized.
Okay, we have more potentials in Nigeria, but the potentials unrealized. Well, I want to say a very big thank you to you, Prof, for coming down. Professor Olu Ojedokun is a professor of law and also the Vice Chancellor, Protestant University, Rwanda. Nigeria owes you a debt for this whole analysis you did here today. And I owe you too, because you opened my mind to some of these things happening, especially in the judicial circle, as it were. Well, thank you so much, Professor Olu Ojedokun. Well, for me, I tell you, the PDP crisis is not just about one party. It's about whether our democracy can survive the judicial roulette. But let's keep this conversation going. Do follow us on all our social media platforms, on YouTube, Instagram, Facebook, TikTok. The handle is at Dominion Broadcast. And on the app X, it is at Dominion Cast. You can visit our website at www.dominion.org.ng. My name is Chike Ubogu. Bye for now.